Which cryptocurrency is being attacked by the SEC after XRP? How long will crypto holders believe in Ripple? How much will XRP cost in mid-2020? 3. We will answer all these questions in today's video. A banking law expert has drawn attention to the problem with using the Howey test to determine whether something is or isn't an investment contract, which could cause the regulator to lose its war against crypto, as the cryptocurrency community eagerly awaits the resolution of the courtroom standoff between Ripple and the United States Securities and Exchange Commission. In fact, Todd Phillips noted a contention from the motion to dismiss in the SEC lawsuit brought against former Coinbase executives Ishan and Nikhil Wahi, which suggests that Howey isn't the best way to determine what constitutes an investment contract. In the tweet thread the legal expert posted on April 8. You also need a contract, post-sale legal responsibilities, and the right to share profit, he said. If this ends up being the litmus test, then it is probable that cryptocurrency assets fall within the purview of the, aside from its application in other court cases, such as that against the cryptocurrency exchange Coinbase. Utilizing this defense would be a serious blow to the SEC's power in terms of more than only regulating the cryptocurrency industry. The Ripple defense team has previously presented this case, according to John E. Deaton, an attorney and amicus curiae for the blockchain business who noted Phillips' tweet on April 9. He added that we are waiting for Judge Torres' decision any day now. The argument was used by Coinbase in its amicus brief in Oahi. Scott Chamberlain, a former attorney and co-founder of the permissionless Layer 2 platform Evernode XRP, had earlier claimed that the lawsuit would have settled long ago if the SEC had just claimed that Ripple had offered XRP as an investment contract, rather than that it was a security. In response to a video of SEC Chairman Gary Gensler shared by Susan Friedman, the International Policy Council at Ripple, Deaton's company Cryptolaw stated that cryptocurrency can't be an investment contract for those who acquire a token on the secondary market, for consumptive use and with no knowledge of, interest in, or rights from whoever previously sold it on-chain. At the same time, according to Feinbold on April 8, Attorney Bill Morgan stated that the SEC's own expert had acknowledged that changes in the prices of Bitcoin B2C and Ethereum, ETH, might account for up to 90s of swings in the XRP value since mid-2018, which he found surprising. As of right now, XRP is trading at 51 cents, up 0.36 over the last 24 hours, but down 2.79 for the last week. Despite this, the digital asset is still holding on to its gains of 36.5 over the previous month. While the cryptocurrency industry awaits the summary judgment in the Securities and Exchange Commission, SEC, lawsuit against blockchain startup Ripple, the case has taken a new twist that has the potential to greatly influence the ultimate conclusion. In instance, lawyer Bill Morgan stated in a tweet on April 7 that the SEC's expert confessed that Bitcoin, Ethereum, and Ethereum, ETH, prices had been responsible for up to 90s of changes in the value of XRP since mid-2018. If the SEC's expert premise is correct, he believes Ripple is indirectly allowing the value of XRP to be impacted by Bitcoin and Ethereum price movements. As a result, the SEC aims to support the allegation by giving proof that Ripple's pricing announcements affect the value of XRP. Significantly, Morgan's theory is supported by the fact that Bitcoin's value changes affect the prices of the majority other cryptocurrencies. Morgan also said that the notion that Ripple's large XRP holdings indicate centralization of the XRP ledger and that XRP qualifies as a security remains. It's worth mentioning that Ripple is being sued by the SEC for selling unregistered securities in the form of XRP coins. As part of its argument, Ripple is appealing for unsealing of Hyman's speech papers, where the regulator described Bitcoin and Ethereum as securities. Surprisingly, Morgan agreed with the SEC's conclusion that investors relied on Ripple's legal efforts to win the SEC complaint. The attorney further highlighted that investors do not expect Ripple's commercial activities to make money from XRP, but rather that the business would prevail in the SEC action. Paradoxically, the SEC may be accurate about investors depending on Ripple's efforts, but not because of Ripple's commercial efforts or XRP sales, but because of Ripple's legal efforts, which will defeat the SEC's case if it is successful, he added. Jeremy Hogan, another pro-XRP lawyer, projected an unexpected conclusion for the lawsuit based on Morgan's words. Hogan predicted that if the presiding judge opted to split the baby, she may determine that XRP sales after mid-2018 were not securities, since the SEC acknowledges that Ripple's activities during that time period had no impact on the token's value. If the judge in the Ripple case wanted to split the babies, awful term, isn't it? She could find that sales of XRP since mid-2018 were not securities, since even the SEC admits that Ripple's activities had absolutely no influence on XRP's price at that point in time. He remarked. Hogan also mentioned the potential consequences of such a judgment, implying that Ripple may be compelled to pay a fine while continuing to operate its company. Moreover, since XRP is the only cryptocurrency with a defined legal position, Hogan believes it may affect the listing of digital assets on multiple trading platforms. Nonetheless, uncertainty regarding the timing for the summary judgment remains. Earlier, several legal experts predicted that the issue would be decided in the first quarter of 2023. Ultimately, the decision of the lawsuit is likely to have an influence on the value of XRP and the whole crypto industry. In the weekly chart, XRP is now trading at 51 cents, up roughly 1. Recently, some members of the XRP community have asked on Twitter why Judge Annalisa Torres has not yet rendered her decision in the case between Ripple and the SEC. Many Ripple and XRP supporters anticipated the judge's decision would come before the end of the previous month, as predicted by pro-XRP attorney James Fallon. This wasn't the case, however, which raised concerns about the delay's potential reason. Attorney John Deaton, the creator of crypto law, outlined the reasons behind Judge Torres' delay in rendering a decision on the lawsuit's summary judgment in a video clip that has been making the rounds in the XRP community. Judge Torres, according to lawyer Deaton, is taking her time to make sure she makes the proper decision because she is aware of the importance of the action. He questioned if Judge Torres had ever experienced the kind of pressure she has in the Ripple litigation, particularly from the blockchain business, during her whole tenure. I sincerely doubt Judge Torres has ever experienced the stress she is now going through. Judge, Ripple is sending look at what the Voyager judge stated, what the Supreme Court said about fair notice, the SEC's actions, Binance, and the CFI's actions, Binance, and the CEFTES, among other things. Deaton was cited as adding. He clarified that these events are taking place at a time when he and many other people claimed that her ruling in the litigation will provide the U.S. crypto market with regulatory certainty. He emphasized that since 1946, the time of the Howey case, the pending Ripple v. SEC complaint, is the most major non-fraud SEC enforcement action. Deaton continued by saying he does not hold Judge Torres responsible for the speed at which she formulates her ruling. Deaton claims that Judge Torres is under a lot of pressure since she is aware that if she rules against Ripple, the blockchain corporation would file an appeal with a higher court. He noted that the judge must provide an explanation of her reasoning if she awards summary judgment to Ripple. So, he added, I don't blame Judge Torres for being extremely cautious about how she works on this judgment because if it goes against Ripple, she knows it's going to a conservative court, and if it is for Ripple, she has to defend it. Attorney Deaton also asked the XRP community to be patient, since the decision is not as straightforward as many believe. Days prior to his most recent statement, Deaton said that Judge Torres may take as long as 2 months to make a decision about the complaint. Thousands of XRP holders are represented in the lawsuit by Deaton as an amici curiae, friend of the court, and she claims that Judge Torres' summary judgment decision often follows her decision on the Daubert motions by a few months. Deaton said on March 31, that the decision might take up to 60 days in light of this.